Assalamualaikum warahmatullahi wabarakatuh. My name is Izzatu Masalah Siti Nasruddin with matric number 200343.
Hi, my name is Safia Maisara binti Wafwan and my matric number is 204057.
Assalamualaikum and hi, my name is Nur Aina Azrin binti Zainur Rashid with matric number 200542.
Hi, my name is Norizati binti Abdul Rashid with matric number 204059.
Assalamualaikum warahmatullahi wabarakatuh and very good morning. My name is Fatin Nadia with matric number 201140.
Do you know that company is governed by Companies Act? There are several steps that needs to be taken in order to create a company. First thing first, you need to know that business entity must go through a legal process known as company incorporation. A company legally incorporated, they will become separate legal entity. Next, there must be some written form that contains all the information that is important for the internal management of a company, and that is known as constitution. Last but not least, you will get to learn about object of a clause for the company. So all these elements will be explained in more details throughout this video. Without further ado, let's start with company incorporation. So, what is company incorporation? Company incorporation is the legal process in creating a company or a corporate entity. Usually, there must be someone to create everything from scratch, and in this business field, we call it as promoter. Promoter will be the one that create the company and will be the one that incorporate the company. Promoter will also be the one that prepare and groom the company so that the company will be able to achieve the goal targeted, vision, and mission. To make it easier to understand, company incorporation is divided into two vital parts, which are pre-incorporation and post-incorporation. Do you know that before incorporation, a company is not a legal entity? Therefore, if the promoter enter into any kind of agreement in the pre-incorporation stage, the agreement is not valid and the company is not bound to the agreement. This is because the company don't even exist yet. So, according to Company Act, there are several steps that needs to be taken in the pre-incorporation. But since we don't have that much of time, I will just take three important steps in the pre-incorporation checklist. These three are steps or part of pre-incorporation checklist that are mentioned in the Company Act 2016. As we can see, the first one under section 14, it said that you need to check the availability of the name before you make any registration. What it meant is you need to find an available and applicable name for your company before you make any registration. Move on to the second one. It mentioned under section 15 Company Act 2016 that you need to issue a notice of registration suitable with what is determined. And the third one is under section 27. It mentioned that you need to confirm the availability and reservation of the name for your company. How about post-incorporation? Okay. Now I will explain about the post-incorporation of company. After company incorporated, they need to follow a sequence of compliances under various legislation. So under section 30 of Company Act 2016, it mentioned that company needs to disclose or display the registration number and the name of the company. And then next, under section 31 Company Act 2016, it stated that all company except limited liability company can choose whether they want to have constitution or not. And both section 30 and 31 is made for public and private company. And there's one more special thing for the public company, which is only public company has prospectus. Prospectus is a formal legal document that stated all important information about the company to the investor out there to invest to the public company. I think that's all from me.
Coverley, the thesis founded a business in 1954 with the help of Christchurch, an accountant in Canterbury, New Zealand. He had majority shares, 2,999 shares of £1 each out of the 3,000 shares, except the one share owned by his wife as a nominee. He was the sole governing director of the Lee Air Farming Private Limited, Berhad, and was hired as a chief pilot under Articles 33 of the Articles of Association at a salary he fixed. In March 1956, he was killed while piloting the aircraft during the course of aerial top dressing. Mr. Catherine Lee, the plaintiff, claimed £2,430 under the Workers' Compensation Act 1922 on the charge that her husband died while doing the employee job, regardless of whether he is a worker under the New Zealand law. The New Zealand Court of Appeals held that an employer cannot be a worker and that the two offices are incompatible and impossible to exist together. However, the Privy Council ruled that an individual in his dual capacity could occupy both positions and that under the separate legal entity, the deceased and the respondent corporation were separate legal bodies. As a result, Mr. Lee was employed as a servant and had signed a contract of employment on behalf of the firm. Therefore, Privy Council advised that the claim of Mrs. Lee is valid as Mr. Lee can have a contract with the company he owned as a separate legal entity. The issues here whether the principle of separate entity applicable or not, or whether Mr. Lee kept the plaintiff liable to claim compensation under the Workers' Compensation Act 1922. The lawsuit was examined by New Zealand's Court of Appeal to determine if the deceased was working as a worker by the respondent corporation under the Workers' Compensation Act 1922. The decision was unfavorable, and the judgment stated that the deceased was the only ruling director for life, with full control of the company. Moreover, there may be a contract of employment between the director and the company. But in these situations, the company only has a single individual with authority, and he cannot be the one issuing orders and obey them. As a result, in this case, all offices cannot coexist in a single individual and are incompatible. Furthermore, the Court of Appeal determined that the deceased's status as a director precluded him from becoming an employee of the respondent company, and therefore it should not be the servant or a worker of the company. The plaintiff then filed an appeal in the Privy Council, where the Lordships considered the precedents set by the Salomon v. Salomon case, which determined that an individual should operate in dual capacities, while the corporation and its sole owner or shareholders remains legal as entities. Similarly, a contractual arrangement existed between Mr. Lee and the respondent company as soon as the company was incorporated, and it cannot be invalidated since the deceased was the majority shareholders and controlling power in the company. It is uncertain what role he was playing when conducting his duties when he was died, but it was done at the request of the farmers whose contractual rights and responsibilities were with the respondent business. Furthermore, the deceased status cannot be used to determine the fact that a contractual arrangement can only be formed between two individual legal persons that has been already established. As a result of the service contract between the company and the worker, the plaintiff was entitled to claim the benefits.
Constitution? What is all of this about? Constitution is the basic principles and laws that determine the power and duties of government and guarantee certain rights for the peoples in it. Constitution of a company consists of Memorandum of Association and Articles of Association. Back then, in Companies Act 1965, Memorandum of Association and Articles of Association were recognized separately. However, in Companies Act 2016, the term Constitution is used to replace both Memorandum of Association and Articles of Association collectively. According to Section 31, Subsection 1 of Company Act 2016, it is not mandatory for a company to have constitution unless the company is company limited by guarantee, which means that the company limited by guarantee is compulsory to have company constitution while others may or may not have it. This has brought us to Section 31, Subsection 3 of Company Act 2016, where for the company with no constitution, the company, each director and each member of the company will have the rights, powers, duties and obligations as set out in the Company Act. However, if they choose to have the constitution, their rights, powers, duties and obligations are permitted to be modified following the company constitution only if the Act permits it. Then, how about the effect of the constitution? The constitution of a company is binding on the company and the members to the same extent, and the effect is similar for all types of companies. For example, is the case of Hickman versus Ken of Romney Marsh Shipbreeders Association in 1915. In this case, it is stated that in the company's article of association provide that if there is a dispute between company and members, the dispute should be referred to the arbitrator. However, Mr. Hickman, instead of going for the arbitration, has continued to directly file actions in court. And the results of the court held that Mr. Hickman must refer the dispute to the arbitration as he is bound to the articles. Secondly, the effect of the constitution is also that it becomes a contract between the members itself. This effect can be seen in the case of Wong Kim Fat versus Leong and Co. Sedrian Berhad in 1976. In this case, one of the articles of the company provided that the majority shareholder could require the minority shareholder to sell his share to the former. In accordance to this case, the majority shareholder has requisitioned the purchase. However, the minority shareholder has refused to follow it. In results, the court held that the minority shareholder must fulfill it by selling his share following the rules stated in the articles. Lastly, I would like to share the effect or position of the Constitution to the outsiders of the company. For outsiders, or also known as third party, their rights in the company constitution is uncertain. Thus, it is suggested for them to enter into an independent contract with the company and incorporate the relevant clause in the constitution into the said contract.
In the previous video, Aina already explained about what is constitution and the effect of constitution. Now, I will continue with alteration of constitution. The Company Act 2016 set out certain procedure which allow for the alteration of the constitution by the company. It can be altered following the procedure laid down in Section 36 and Section 37. Changes made to the constitution may involve a change of name and alteration to the main object of the company or other clauses. There are two methods to alter the constitution. The first one, alteration made by the company, and the second one, alteration made by the court. Let's start first with alteration made by a company. A company may alter its constitution by passing a special resolution. A member must vote for the benefit of the company as a whole. This is to prevent the majority shareholder from exercising their vote to alter the constitution to the prejudice of a minority. However, alteration to the constitution may also be subjected to certain restrictions, like if a provision under the constitution expressly prohibits it to be altered and should only be done if it is bona fide for the benefit of the company as a whole, as laid down in the case of Allen versus Gold Reef of West Africa. Let's go through this case. In this case, Allen had both fully paid up shares and partially paid up shares. Despite repeated calls, he failed to pay up. The company altered the constitution to the effect that in the event a member failed to pay the cost of his partially paid up shares, the company would have a lien on the fully paid up shares as well. The court held that even though the alteration was prejudicial to one shareholder, it was bona fide for the benefit of the company as a whole. Therefore, the resolution was held to be valid. Next, alteration made by the court. There may arise situations where it is not practical to alter the constitution of the company using the procedure prescribed in the Company Act. Therefore, Section 37 of Company Act 2016 provides that a director or a member may then apply to the court for an order to alter the constitution, and then the court may grant the order on such term and condition as it thinks fit. Now, let's continue with lodgement with the Registrar of Companies, where the constitution is altered by the company passing a special resolution. Section 36, subsection 3, the Company Act 2016 requires the company to notify the registrar of the alteration and lodge a copy as altered within 30 days of the special resolution being passed. Same goes where the constitution is altered by a court order. The company needs to lodge an office copy. The company needs to lodge an office copy of the court order together with the altered constitution with the registrar within 30 days from the date of the order as required in Section 37, subsection 2 in the Company Act 2016.
So, let's do some recap. In the previous video, we have talked about company incorporation, separate legal entities, and constitution of company. So, what's next? Last but not least, about object clause of company. What is the meaning of object clause? Object clause is the object of which the company is formed. It is the most important part of Memorandum of Association. It indicates the range of scope and limitation of which the company can form. So the company only can do activities that is stated in the object clause. The company must keep in mind that the object must be defined as following. Firstly, the object must be legal. Secondly, the object must not contrary to public policy, contravention of Companies Act, or provision of any law. Thirdly, the object must not be immoral. I already explained to you guys about object clause of company, but what happens if the company do activities which is beyond its object clause? This can be explained more in the doctrine of ultra vires. Ultra means beyond, vires means power. Let's take an example of a case law between a company and a guy. The company name is Ashbury Railway Carriage and Iron Company Limited versus a guy which is Richie. The company objectives is actually to make and sell or lend on hire railway carriage and wagons and much more. But the company agreed to give Richie and his brother a loan to build a railway in Belgium. Later, the company repudiated the agreement, so Richie sued the company because the company is breaching a contract. But the company pleaded that the action was ultra vires. The contract between the company and Richie to construct the railway is actually not mentioned in the object clause of the company. This meant that Richie's claim against the company for breach of contract failed as there was no contract to be enforced. It was held as the company cannot do outside of its objective. The conclusion is an ultra vires act is void and cannot be ratified, even if all directors wish to ratify it. The company must keep in mind that they only can do activities which is incidental or consequential upon its own objective clause. The meaning of incidental is actually which is related to the main activity, consequential which is mean resulting from main activity. So the company must keep in mind that they cannot do anything beyond or outside of its scope of its objective. However, alteration in object clause can happen, which is the company must pass a special resolution and obtain permission from company law board. At last, we have come to the end of our video. Thank you so much for your attention. We really hope you guys have gained some input from our video. So we'll see you guys in our next video.
Bye.
Bye bye.